I'm Vinnie Politan. Thank you for joining us. Some breaking news. Yes, red tie. It is verdict time in New Mexico. Isaac Apodaca accused of manipulating his girlfriend, Kiara McCulley, to murder their friend, Grace Jennings. The jury was out less than 2 hours. Less than 2 hours. Let's take you right inside the courtroom. This may not be good news for the defendant. Let's take you in.
The court has returned the verdict forms as well as the 22 jury instructions that were sent back to deliberations with the jury. Mr. Apodaca, counsel, would you please rise? In the state of New Mexico versus Isaac Sampson Apodaca, cause D101 CR 2023-25. We find the defendant guilty of murder in the first degree as charged in count 1, signed by the foreperson, the corresponding not guilty verdict form for count 1, and the two guilty and not guilty verdict forms for, second degree murder have been left unsigned. With respect to count number 2, we find the defendant guilty of conspiracy to commit murder in the first degree as charged in count 2. The corresponding not guilty verdict form is left unsigned. You may be seated.
Thank you.
Do the parties wish the jury to be polled?
Yes, Your Honor.
Yes, Your Honor.
Okay. Ladies and gentlemen, either party has the right under our rules to ask that the jury be polled. So what that means is I'm going to start and ask each of you as to each count if the verdicts that I have received represent your verdict. So I'll start in the back row, and then I'll come around the back row, and Mr. Foreperson, I'll speak to you last. Okay. Juror number 1, with respect to count number 1, the jury has returned a verdict of guilty. Is this your verdict, and was this your verdict at the time the vote was taken?
Yes.
Juror number 2, as to count number 1, was this your verdict, and is this your verdict?
Yes.
Juror number 3, was this your verdict, and is this your verdict?
Yes.
Juror number 4, was this your verdict, and is this your verdict?
Yes.
Juror number 5, was this your verdict, and is this your verdict?
Yes.
Juror number 6, was this your verdict, and is this your verdict?
Yes.
Juror number 7, was this your verdict, and is this your verdict?
Yes.
Juror number 8, was this your verdict, and is this your verdict?
Yes.
Juror number 9, was this your verdict, and is this your verdict?
Yes.
Juror number 10, was this your verdict, and is this your verdict?
Yes.
Juror number 11, was this your verdict, and is this your verdict?
Yes.
Mr. Foreperson, was this your verdict, and is this your verdict?
Yes.
The jury has been properly polled with respect to count number 1. With respect to count number 2, the verdict returned by the jury was guilty of conspiracy to commit first-degree murder. Juror number 1, was this your verdict, and is this your verdict?
Yes.
Juror number 2, was this your verdict, and is this your verdict?
Yes.
Juror number 3, was this your verdict, and is this your verdict?
Yes.
Juror number 4, was this your verdict, and is this your verdict? Juror number 5, was this your verdict, and is this your verdict?
Yes.
Juror number 6, was this your verdict, and is this your verdict?
Yes.
Juror number 7, was this your verdict, and is this your verdict? Juror number 8, was this your verdict, and is this your verdict?
Yes.
Juror number 9, was this your verdict, and is this your verdict?
Yes.
Juror number 10, was this your verdict, and is this your verdict?
Yes.
Juror number 11, was this your verdict, and is this your verdict?
Yes.
Mr. Foreperson, was this your verdict, and is this your verdict?
Yes.
The jury has been properly polled with respect to count number 2. Ladies and gentlemen, at this time, having completed and returned verdicts, I'm going to discharge you as the jury in this case. So a couple of quick instructions and then I'll let you go. First of all the restrictions that were placed on you at the beginning of the trial are now lifted. You can talk to anyone you want to about the case. You can look up the names or any information about the case. All of those restrictions are lifted. You control all communications, so you can pick and choose if you want to talk to someone about the case and not to. Sometimes the attorneys want to speak to jurors. The way that happens, we have a special way of doing it. They have to notify the clerk of the court downstairs on the first floor. She would get the information and she would contact you and give you their contact information, and then you decide whether or not you want to return the call or the text message or the email. So you control all communications. No one should, none of the attorneys or their staffs or investigators or anybody should, come to your home or your work or anything like that to talk to you. If someone does approach you and you don't want to speak to them, simply let them know. And if anyone persists beyond that point, let me know, and we'll put a stop to it very, very quickly. With respect to your service, since you've sat through an entire trial, I give you the option if you want to be taken out of the larger pool for the rest of your service. All you need to do is let Angel know, and he'll let the jury clerk downstairs know. If you want to remain in the larger pool, you can. You may or may not be called back during your term of service. And if you remain in the pool, you'd be contacted in exactly the same way that you were contacted to be present for jury selection and to come back for the trial. Any questions about any of those issues? Okay. The other thing, I need to make sure you leave your notes with the bailiff. Your notes, along with the notes of the alternates, will all be destroyed. Have you retrieved all of the exhibits? Okay. So that was the other thing I need to check on. We need to have all the original exhibits back in the court's custody. The last thing I want to talk to you about is this experience. It is not normal for most of us to sit through a trial or a hearing or any kind of a forum where, you've heard testimony from the Office of the Medical Investigator, you've seen crime scene photos, you've seen autopsy photos, you've heard the testimony in the courtroom. We've come to know over time that this process can inflict a type of trauma to individuals. So Angel will give you a pamphlet that's been prepared by the Administrative Office of the Court that just discusses that. I've been talking to juries now for over 10 years about this issue because I had a situation where a couple of years after a trial, I ran into, just by happenstance in the community, a former juror, and part of that conversation was how they were still had a problem, were kind of upset, disturbed by their experience. After that conversation, I asked them, what they had done to kind of process the whole experience. And the response I got was, well, nothing. I would suggest to you that you take some time in the next couple of weeks in whatever you normally do in your life to deal with complex emotional situations and things that you've been exposed to, that you take some time and actively process what you've been through. And again, whether that's having a conversation with a friend over a cup of coffee or going for a walk up at Aspen Vista up in the mountains, whatever you normally do, I encourage you to take some time to do this in the next few weeks so that you can kind of put this in context with the other things that have occurred in your life and hopefully help you to heal and move on. Do any of you have any questions for me about any of that? So what we're going to do is I'm going to discharge you in just a moment. Angel will walk you out. The rest of us will remain in the courtroom. Once you're past the guard station at the front of the building, then I'll release everyone else in the courtroom. Last thing I'd like to say on behalf of the court, all of my staff and the parties, we'd like to thank you for your patience. Didn't know we were going to have a power outage today, but thank you for your patience during the trial, your attention, your commitment to the process, and all the work that you've done. I discharge you as the jury for this case. Would all rise while the jury departs? All rise. Thank you all. If you go with the bailiff, please. You may be seated in the courtroom, ladies and gentlemen. Are they on? Do you know? We'll set sentencing probably about 30 days out. We'll send you a notice of the hearing and give you ample time to make whatever information you want the court to receive and to review before the hearing. Anything that you send to the court, you need to share with opposing counsel and send a cover letter indicating that you've done that. Okay. Is there anything else before we go off the record in this case from the state? Ms. Murphy?
No, Your Honor, nothing from the state of New Mexico.
On behalf of Mr. Apodaca?
A few issues, Judge. First of all, I just want to inquire of the court, was the jury deliberating I mean, if the jury was deliberating on the power outage, were they adequately supplied with technology and different things?
They had their own lights back there. We provided them lights. They had verdicts. I was informed about not long after the power went out. And so they were sequestered in the back without anyone having an access to them until they were called into the courtroom now.
So they had a generator or something back there?
They were using cell phones and flashlights to light up the jury deliberation room.
Okay. And this is one case, Judge, where I think we'll need a mitigation report from a qualified expert in regards to Mr. Apodaca's history of trauma and various different issues. So I don't know if the court wants a formal motion to continue
Yes.
the 30, or if we...
Yes, we'll give you a date and then they'll need to file a motion.
Okay. All right. Thank you.
Anything else, counsel?
Nothing for defense. Thank you.
Okay. Mr. Apodaca?
The order for ad seg.
I'm sorry?
The ad seg order.
Oh, yeah. Can we have him removed from SEG?
Yes.
And phone.
I need an order. My administrative assistant, we have a video hearing, so she's back there dealing with that. So I'm not sure she's listening to us to prepare the order, but he'll be released from administrative segregation and his phone privileges are restored.
Okay.
Mr. Apodaca, you've been convicted by a jury of your peers. We're going to set sentencing out for about 35 days. It may be a little bit longer than that based on what your attorney just told me. But at this time, I'm remanding you into the custody of the sheriff of Santa Fe County to be held in safe and secure care until further order of the court. He's in your custody, Sergeant. Do you need to speak to him, counsel,
Yes.
before they take him back?
Yeah.
Sergeant, if you'd give him about 5 minutes in the back before you take him down.
Yes, Your Honor.
Thanks, Judge.
Okay, we're off the record. The rest of us are just going to sit for a few minutes.
Likely the last time he's going to be wearing that nice suit. Isaac Apodaca has been convicted. Didn't take the jury long. There was a power outage, ironically, right? The power goes out. Oh, we've got a verdict. Less than 2 hours. This is a case, you think about what he did and the level of evil that it took. He's manipulating a young woman who's his girlfriend, who's obviously mentally ill. She's got issues. She's a murderer also. Like, she knew what she was doing. But he knew that he could control and manipulate her and convince her to take a sword and plunge it through Grace Jennings. And for whatever reason, both of these young women saw something in this young man. I don't know what. It's beyond me. And it must be because they were vulnerable, both of them. We know Grace Jennings had a difficult life as well, a very difficult life. So maybe there was some way that he was able to latch on and manipulate them. What surprises me, though, is the way it played out. I almost feel like Isaac Apodaca seemed more like a potential cult-type leader than a killer of one of his followers by another one of his followers in all this. Because for whatever reason, these young women paid attention to him, believed in him, and listened to him. They both dated him as well. But in the end, the truth came out inside the courtroom. It was not easy for Kiara to get it all out. She's got serious, serious issues. But from my perspective, that played right into the prosecution of the case. This is someone who could be manipulated into doing something that awful, doing something that evil. So a sense of justice for Grace Jennings. But at the end of the day, this was so unnecessary and only happened because of the evil of Isaac Apodaca. I want to bring in our guest who's been standing by to get her take and reaction to all of this. Trial attorney Terry Austin is with us. Terry, great to see you. What are your thoughts here? Because I look at a case like this, anytime I have a case with young people, and you know, like we're sitting back here, we're realizing like their lives, like one life is over and two other lives will be behind bars for a long time. And how in the moment do they think that this is something we should be doing? From his perspective, I only see evil.
Right. I think this is what you said, Vinny. You hit it on the head. This is like Isaac was a cult leader. The fact that he was able to convince these women to do whatever his bidding was. He talked about, this organization and getting points, and he's killed 40 people, and he got Kiara to do the same thing. And it's just really an interesting situation where all of these young people don't think about the ramifications. How do you kill someone like this so brutally and not know what you're going to do as far as the body is concerned? Obviously, this is premeditated. Obviously, it's intentional. Obviously, they shouldn't have done any of this. I think they all have some very serious issues. But no matter what, if you're going to murder somebody, if you're going to plan this out, you have to figure what the consequences would be. How do you hide this? Where do you put the body? He Googled to hide the body, to get rid of the body, but he never did anything about it. So they did not think about what the ramifications would be. And obviously, they've affected so many families. Grace Jennings has a family who is grieving for her now. And to your point, these two killers, one has pled, the other is now convicted. They will be behind bars for a good part of their life, if not for the rest of their life.
Yeah, and such a waste. Like the whole thing is just a complete waste. What I don't understand is this is a young man who brought absolutely nothing to the table, like zero to the table. And it almost seemed during Kiara's testimony, like her reaction to him being there, that there was still some level of, I don't know if it's control, but like she was drawn to him for some reason. Like he's not good looking, he's not smart, he's not well spoken, he has no money, and he's lazy and he doesn't work, right? And because he wasn't working, what did he do? He pimped her out. And yet she still feels this attraction to him, which shows me the level of control that he had.
Absolutely. And not only that, I mean, everything you said is absolutely true. I don't know how these women were attracted to him. He has no job. He's living in the garage of his girlfriend's parents' house. And to your point, he did pimp her out to make money. He has nothing to offer. I'm glad you said it, but he's not an attractive man. At least, he could make the most of what he has, and it doesn't seem as though he's done that. One of the things, though, Vinny, that I think he has going for him is he is a little older. He's 25. I think at the time Kiara was 19, if I'm not mistaken. And I do think some of the influence that he had to do with the age and the difference in the age. Obviously, it's not that many years. I think I heard you say this the other day. It's not that many years, but at that age, it is more years. And so I do believe that part of the attraction was this older man paying attention to me and being with me and controlling me and wanting to be controlled. They did all have issues, though. And when I saw Kiara on the stand, her affect, I mentioned this earlier, it's just as though, she is easily manipulated. She seemed genuine and sincere, but at the same time, she's delusional. I do think the jury listened to what she had to say and felt bad for her because she was really extremely manipulated by Isaac.
All right. We've got a lot more to get to. Thank you so much. Terry's going to stick around. We're also watching another case down in Georgia. We've got another verdict watch going on. Like, am I going to have to keep this red tie on for the rest of the day? You're watching Court TV Live.
And I think Dwayne has said deals with malice murder.
All right, let's take a look at what's happening in Georgia. We're covering another case involving another woman accused of murder. This one, Kiana Davis, accused of the murder of her 7-month-old child, Carter. There's little Carter. It's difficult to think about what happened to Carter, 7 months old. Fatal blunt force trauma, a lacerated liver. Let's take a look at what's happening in the courtroom. We're waiting for the jury to come back. 2 years old, blunt force trauma. Oh, absolutely heartbreaking what happened to that little guy. The question is his mother, Kiana Davis, responsible? That's what the jury has to figure out. They've been out for about an hour and a half, so we're keeping an eye on what's happening there. In the meantime, with all the other news happening in the world of true crime, we are now catching you up on the closing argument from the defense. Let's take a look.
As Mr. Dwayne has said, deals with malice murder, malice aforethought. And I think Mr. Dwayne was, I guess he was saying, when he was telling you that my client beat this child to death. Beat this child to death. And the judge will explain to you what malice aforethought means. She'll explain that to you. But that's what the state is alleging in count one, that Miss Davis beat her own child to death. And of course the state has said that they don't have any eyewitnesses or any factual evidence or direct evidence of that nature, that it's all circumstantial. And the judge will tell you the difference between direct and circumstantial evidence and what can be used. We understand that. But the burden is on the government to prove the charges as to malice murder. Malice murder is in our way of doing business in the state, that's the most serious offense that the state can charge somebody with. For beating someone to death. I mean, you see malice murder in cases where someone's been shot or been pistol whipped, or I mean, and the state has said that they have no theory on what sort of weapon there was. Not that they have to, but they don't have that. So, I mean, you've seen Miss Davis in trial this week, and you've seen her testifying, and they're saying that either she did it maliciously, with malice aforethought, and they've also got Keon Benton charged with the same thing. He's not here. He's not here. Of course, they're being tried separate, but if he was there when this happened, then why is he not here to testify against Miss Davis? Because it didn't happen. Malice murder. The most serious of any murder that there could be in our state. You know, the other charges, 2 and 3, felony murder with the separate predicate offense being cruelty to children in the first degree. And then count 4, felony murder, the predicate offense being count 5, aggravated assault. And of course, the indictment here says in felony murder that the child was beaten with an object, the exact nature of which is unknown to the grand jury, caused cruel physical pain, that being a lacerated liver to the victim. Well, circumstantial evidence is what they've established. And circumstantial can be okay. Not in this case. Aggravated assault being circumstantial evidence that the child was struck by an object unknown to the grand jury. Okay. See, you sort of need to break down you either have a malice murder, you have a felony murder with these underlying predicate offenses, or you have what's in 5 and 6, which is an unusual charge in our state, but it's a valid charge of murder in the second degree. And you'll need to read the indictment on this one, that murder in the second degree occurs irrespective of malice, meaning there doesn't have to be malice. You have to show, or the state has to show, that they have established that the child suffered cruel physical pain by the failure of the mother to seek immediate medical attention. There has to be criminal negligence there. Criminal negligence. In other words, I mean, the state says something about wanton disregard or just, not just failure to act, but intended to act that way.
All right, we'll get you back down inside the courtroom in just a moment. We're going to take a break. We've got a lot more to get to here. This is Court TV Live, and we are in another verdict watch. Welcome back to Court TV Live. We got some breaking news out of Georgia where we're in a verdict watch in the case against Kiana Davis, accused of the murder of her 2-year-old son, Carter. Right now, the jury apparently has some sort of a question. Let's take you inside.
All right. Okay. We have two more questions from the jury. First, what about if we believe the injury happened on Saturday, the 14th, but the indictment lists 15th to 17th? And then the jurors would like to ask if we can come back tomorrow. So first, on or about means if they think it happened on the 14th, I think that's sufficient. There is some language about that in the law that I want to be precise in how we charge them on that. And the other thing that's messy in trying to answer that question is the death occurred on the 17th. And so the elements of the crime, you see what so if it's felony murder and the aggravated assault, it's a little bit messy. So y'all take a minute and think about what you think is the appropriate response to that. I don't think there's any question that the law says, and the indictment reads on or about, or on or between, whatever. So I don't think that is dispositive of the issue. And then, hang on, I'm going to let you both say what you want to say. And so when you are telling me what you think about it, number one, also, does it matter which charge we're talking about when we're talking about the date? Because does the homicide happen the day the injury is inflicted, the day of death, either or, depending on how it's indicted? And so those are the sorts of things we need to consider when we're talking about how we respond to that question.
May I?
Yes.
So I've used a charge in the past where the date is not a material element,
Right.
And they can be charged with that, and I can run back to my office and try to find a copy of that.
Well, that's what I was talking about when I said the on or about. I probably can pull it right here for you, but I think that's the start of the conversation.
May I respond?
You may. Go ahead, Mr.
Your Honor,
Burton.
please. Normally an indictment will say that, but the indictments on all these counts say between the 15th day of November of 2020 and the 17th day of November of 2020. The exact date of the offense being unknown to the grand jury. I say that because all of the counts say that. It doesn't say on or about.
Okay. But it does say on or between and the exact date being unknown. And I think that if you look in, so there are some cases, as he's saying, the date recited in the indictment is not a material element of the offense unless the indictment specifically provides to the contrary. So as long as the offense occurred within the statute of limitations. A date is a material allegation of an indictment if it is an essential element of the charged offense or if a defense such as alibi has been asserted. And that is not the case here. And let me look at the specifics of this. I'm looking at some cases, hang on. All right, if you look at Townsend v. State, which is 357 Georgia Appeals 111, this actually is working in reverse. So it's well settled that the date is not a material element, and as long as it is proved within the statute of limitations, in the absence of a specific allegation that is a material element or an alibi defense, then you're not stuck with the date. And in Townsend, this is actually a post-conviction argument about merger and whether these theft crimes merge. And the state is arguing that they do not because they were alleged to have happened on different dates. But they're all the same victim, the same stuff, and they do merge because the state failed to allege the date was a material allegation. So I think, whichever way you come at it, the answer is that the date is not an essential element of the crime charged as long as the crime has occurred within the statute of limitations.
And we will not concede that point.
Okay, then that's fine. And so, let me, I want to look at one other thing before I All right, and if y'all look at Reed v. State, which is a Supreme Court case from 294, Georgia, 877. That's March 28th of 2014. Where the date is not alleged to have been an essential element, the defendant did not assert an alibi, and this is a homicide case, and so
Okay, we're going to take a short break while they are figuring out the law on this, but I think if she's convicted, I think we have issue number one on appeal will be relative to this note. This jury says they believe things happened on the 14th, but the allegation is between the 15th and 17th. We'll be back. Welcome back to Court TV Live. We are in a verdict watch, but the jury has a question in the case against Kiana Davis in Georgia. Let's take you back inside the courtroom to hear how the judge is trying to wrap this up and respond.
Respond to this question is, the state is not restricted to proof of the date stated in the indictment. It is sufficient if the evidence proves beyond a reasonable doubt the offense or offenses occurred within the statute of limitations.
Can you repeat it again? Please.
The state is not restricted to proof of the date stated in the indictment. It is sufficient if the evidence proves beyond a reasonable doubt that the offense or offenses occurred within the statute of limitations.
I think that's okay.
Mr. Greer.
Of course, I don't have any legal cases to cite to the court, but I would object to that.
All right. Your objection's noted for the record. I'm going to give that, I'm going to write that exact wording down to respond to their question.
And I have no objection to them coming back another day.
Okay, and I'm just going to tell them the choice is tonight or Friday morning at 9.
I would ask them to see if they'll return the verdict tonight, Judge, based on.
I'm going to let them choose if they want to stay tonight or they want to come back Friday. And I'll just tell them that they've been on our schedule, we're on theirs.
Yes, Your Honor.
But I need to not write and talk.
Sends the note back to the jury. Let's take you back in to see how the jury is going to respond. Do they want to stay late or just come back fresh on Friday?
Note says, we have one juror who says she isn't open to discussion, who is combative to the room. What do we do here? She said she will not change her mind in a million years. Please advise. So, the issue for the court is a juror should never surrender an honest opinion, but a juror does have to participate in deliberations. So my suggestion at this point is that we Allen charge them, because that talks about you have to listen to each other. Let me pull that and look at the pattern. Because we have to be very careful with investigating which it is. That a juror has a belief based on the evidence that they're unwilling to surrender, which the system is set up for, or whether a juror is just refusing to deliberate.
Judge, I would argue to the court, I don't think we've got far enough yet. I think it's probably too early to do an Allen charge.
Okay, go ahead.
I would suggest that we come back Friday morning and give them some more time to deliberate And then after a period of time that the court deems appropriate, if the stance is still that way, then do the Allen charge.
Well, I think it's not so much the first paragraph of the Allen charge, but the second part that says each juror should listen to the arguments of the other jurors with a disposition to be convinced by them. If the members of the jury differ in their view of the evidence, that difference of opinion should cause them all to scrutinize the evidence more closely, re-examine the grounds of their opinion. Your duty is to decide the issues that have been submitted to you. If you can, conscientiously do so. In conferring, you should lay aside private opinion. Bear in mind that the jury room is no place for taking up and maintaining in the spirit of controversy either side of a cause. You should bear in mind at all times that as jurors you should not be advocates for either side. You should keep in mind the truth as it appears from the evidence, examined in light of the instruction of the court. I would encourage you to continue this case. I mean, because just sending them home is not going to change the dynamic. I don't know that the dynamic should change. I don't know what, because combative is one thing, never surrendering an opinion in a million years is a different one from a legal standpoint. And the court has to be very careful in invading the province of the jury. However, I'm talking myself around into what I think is the appropriate thing. It is late. Everybody's tired. I think I'm going to send them home, tell them to come on back Friday morning at 9, that and I may, then we'll I'm open to thoughts on whether I should address, if I need to address this at all or just send them home today.
I'm in agreement to send them home and bring them back Friday morning.
Mr. Groom?
I would think so also.
All right, if that's what y'all think. Bring them in for me, Mr. Douglas.
Do you want alternates, Jeff?
Yeah, because we may need them.
Okay, I'm going to update myself here. I said at first the whole thing about the date was going to be issue number 1 on appeal if, and it's the big if she's convicted by this jury. This now becomes the big issue. It seems like we got a holdout. It could be one way or the other, but if there was a conviction, this now becomes issue number 1. I want to bring back in Terry Austin, our special guest who's been joined. This is getting messy. This is when things kind of go off the rails a little bit because there's a little bit improvisation by the judge. What should we say? The attorneys this is very messy, and I'm very concerned that if there is a conviction, that's a big if here, based on where we are, that this conviction might not stand if the judge makes the wrong little decision here in how she handles this jury.
I agree, Benny. I think that she should take each issue separately. I mean, the first issue, should we come back Friday? Yes, I guess they're doing nothing Thursday, so come back Friday at 9 o'clock. Fine, that's done. Just answer that question. The other question is whether or not this cruelty charge is outside the statute of limitations because the failure to provide care could have occurred long ago, and I think the defense is not going to concede that point. She needs to find a jury instruction that deals with that matter. So as a matter of fact, the jury can make that determination. And then the biggest issue here is the fact that they apparently are at a, deadlock. This one juror apparently isn't going to change her mind after a million years. So the question is, do we just give the Allen charge or do we give a lesser charge? Either way, the good news is for this judge, both sides have agreed that they'll come back Friday. Maybe things will change at that point. Maybe they'll have all of the jury instructions ironed out and they can send that back and we can probably move forward as far as this case is concerned.
Yeah, this is kind of the point in case where many times mistakes can be made. But if you give yourself a day and a half, you do the research, you ask both sides to come back with what they propose should be said, it can be a little bit cleaner. The bottom line is, though, that this jury is not in agreement, and that's always better news for the defense.
Absolutely, I agree. I think the defense is happy about that because it sounds to me, you said it earlier, we don't know which way this deadlock is going, but it sounds to me, just based on the evidence, and it does seem to be quite a bit of evidence against the defendant here. She was the one who was in custody of the child before, he got really ill and had to go to the doctor. I think the holdout might be for her. So we'll see what happens.
We will. Terry Austin, thank you so much for staying with us and giving us a lot of insight. Great to see you. Have a great day. All right, folks, when we come back, we've got another whole hour here. So what are we going to do? We've got one jury going home. Oh, we've got a preview of the biggest trial of the summer. When we come back, a deep dive into the case involving Lindsay Clancy, the woman who is now confined to a wheelchair and has 3 dead children. We'll be back.